Jeffrey, I heard you got hit by a car this morning. Are you alright?
I'm bruised and sore, but the doctor says I need a few weeks of rest. It happened right on my way to work.
That's unfortunate. The other driver is at fault, right?
Yes, the police report says the other driver is mainly responsible. I wanted to ask if the company can help me apply for work injury recognition.
Work injury? That might not be necessary. You can just take sick leave while you recover. Work injury filings are complicated and costly for the company.
Actually, Edgar, since the accident happened on his normal route to work and the other driver bears main responsibility, Jeffrey's case meets the criteria for work-related injury.
But if we recognize it as a work injury, doesn't that create extra costs? I remember Miss Lee's case. 6 months of full pay during medical leave, plus all her bonuses. Later, we had to pay double severance when she left, even an employment subsidy.
That is true, but those obligations are required by the law. If it is a legitimate work injury, you can't just avoid it to save money.
I'm not trying to cause trouble. I just want a proper fillings of my medical expenses and recovery period are covered. That's what the policy is for.
Fine. But what if we just settle directly? How about N+1 compensation and we end this quietly?
That wouldn't be fair. It isn't a voluntary resignation. It's an unlawful termination if you end my contract while I'm still recovering from a work injury.
Jeffrey is correct here. Dismissing an employee during the work injury treatment period is illegal, unless there is serious misconduct. Offering compensation doesn't make it lawful.
Then there is no other way. I will issue a termination notice. We lost arbitration. I thought offering compensation would protect the company. Why did we lose?
During the work injury treatment period, an employee cannot be dismissed unless they violate serious company rules. Since Jeffrey didn't, this termination is invalid.
So the company has to restate me.
Yes, the arbitration decision was to restore the employment relationship, and the company must also pay unpaid medical leave wages and 3 months of regular salary for the time before reinstatement.
So all this trouble could have been avoided if we had just processed the work injury claim properly.
Exactly. Once a case is acknowledged as a work injury, you can't fire the employee just like that. If you insist on doing so, you owe him 2N as severance, and the employee is still entitled to additional work injury compensation.
All right, lesson learned. Jeffrey, where did you find this lawyer?
I watched Edgar's video online.